just want to bring to your lordship's notice, my lord, one very disturbing news report, my lord, reported in Shillong Times today, my lord. On the, my lord, on the top right-hand corner, Shillong, the city grapples with water crisis. My lord, it started, your lordship, initially there was a notification 4 days, started on 10th.
I think we passed some order.
No, my lord, regarding
What's water matter?
that is, I think, regarding boring. No, my lord, from 10th it started for 4 days. Thereafter, it was never restored. Now the reports say, my lord, things are very uncertain, and the way it is being carried out. Till now, my lord, not a drop of water in 90% residential area of
Yes,
Shillong.
Mr. Advocate General.
We will take note of this matter, Lord, and
We'll register
Lordship,
this. We'll register this.
yes, Lordship. Your Lordship may have it tomorrow. By the time I will take the instruction
Good.
also. Graph is there.
Mr. Shubir Sen, Learned Senior Counsel, Learned Counsel, has mentioned skip this. That's it. Otherwise, yes.
Lordship, I beg to mention on item for urgent listing, Lordship, for tomorrow.
Division bench,
Lordship,
DB1.
Lordship,
You.
I know, Lordship.
Have you given notice to the other side?
May it please your lordship. Lordship, I beg to mention an understanding matter for tomorrow, my lord. It's before division bench 2, my lord. Tomorrow it seems there is no bench constituting Justice Varajaji and Justice. Thank you. It's a GST matter, my lord.
Single bench. To constitute a bench.
My lord.
Place it before me to constitute the bench.
Lordship.
And your matter, you are appearing, Mr. Advocate General, in the
No,
three
not GST. I have no idea.
No, not GST.
For
The matter you mentioned.
Mr. P.T. Sangma is appearing, Lordship.
So, state is party in this
No,
matter?
no.
State is not party in this matter.
Then who is the party?
Mr. P.T. Sangma.
Private,
Private.
private dispute.
It's a private matter.
Regarding to PIL 15th of 2025, Lordship, with GHADC matter, Lordship.
No, we have heard this matter.
This is regarding the separation of judiciary, where the
Lordship,
judiciary have not
We
been
have passed an
separated.
order.
Yes,
Lordship,
there's
with
nothing
regarding
to
to that-
modify that order.
to modify that
And
order.
moreover, this prior to filing of the petition only, they have
No,
circulated this.
we have fixed this matter sometime when Mr. Advocate General was appearing in this
Yes,
matter.
It is coming on 20.
it is coming, I think, my lord, after vacation. Vacation, immediately
Yes,
after
after vacation, the matter
yes.
is listed.
Lordship,
Yes.
Miss
And
case
moreover,
has
they
been
have
filed.
appointed another.
Lordship, Miss case has been filed. Lordship,
No, but what is the urgency?
Lordship,
What's the urgency for mentioning
Lordship.
it today?
Since in the order, Lordship, the secretary has been removed from
What we have done is this: we separated it.
Lordship.
We separate the person from the secretariat and put it in the judiciary. So that's what we have done.
Lordship, if may
They have
tomorrow,
already
Just a minute.
I'm sorry.
my learned senior is more aware of this matter, Lordship.
No, what's the urgency here?
Where's the
Appealing for-
urgency?
You're appealing for the person who's been removed. The
Lordship,
secretary, that,
Lordship,
Mr. Marak.
Lordship,
We are appealing
What-
for him.
Why
Lordship,
you aggrieved?
Lordship, because he has been removed from that.
It's a question of removal. It's a question of just separation, that he is divested of the duties only, then he's doing the judicial work. That's all.
Lordship, but then he was firstly appointed as a secretary, Lordship, and then the duties as
He was holding additional charge as a
Later.
judicial officer.
Then
So
you file in affidavit.
he wants to remain as a
Secretary.
yes,
Yeah.
secretary, and he doesn't want to discharge the function of judicial officer. So because he says that probably his parent cadre is the executive, and he cannot perform the duty. So and he was assigned additional duty as a judge. So he says that I should remain in as.
Someone has to be appointed.
Yes.
Now, but then if he is going to the secretary, he becomes a secretary, then who will perform the judicial work?
Lordship, then the executive committee has to look into it. Lordship.
You are there, Mr. Dey, you are
Yes,
appearing.
This
So if-
application has been moved by the person who's aggrieved, my lord. I have communicated.
See, district council is the authority to take a decision.
Yes,
So you have a power either to keep him as he cannot have a choice.
my lord.
The person cannot have a choice. You cannot say that I will continue. It is a choice of the district council.
Right.
This application is not maintainable at your instance even. How he can say so? What right he has? He cannot be a person aggrieved. The district council, we can modify to the extent the district council will take a decision whether you should continue as secretary or additional judge. That much we can do. But you are at your instance, this application is not maintainable. Sorry. There is no urgency. Sorry. No tomorrow. Not tomorrow. You cannot file an application. It is the choice of the district. If the district council files, you shall sit with it.
Moreover, Lordship,
How you can claim that you should be attached to your post? How? What right you have? Show us a legal right that you have right. You don't have a legal right. It is for the district council to come and say, I would have followed district council come and say that no, we appoint you as secretary, please discharge him from this, we'll appoint an additional judge. That is understandable. But not at the instance of the person whom we have said that he should cease to be as a secretary. Because he's also have a qualification, I think he's a law graduate as well.
Law graduate.
It is not, this application doesn't lie at your instance. We can list the application and say so. List this application, tomorrow we'll dispose it of. It's something unique.
Lordship, they have already appointed another joint secretary. They have there is notification. They have appointed another secretary now in place of R. Marak SIM card.
Then you have
It's not
already
required
done so.
anymore.
We just put it.
There's a notification,
Yes, no, right.
Your Lordship.
Lordship, it
List
will
this
come
application
up
and dispose it
tomorrow.
of tomorrow.
CM of GHTC have already appointed. There is a notification on 11 December
What right you have? You
2055.
don't have a right.
Lordship, my
In
learned
view of
senior
the
will
order.
Better to
My lord, I will take that.
appraise school.
Let's pass this order. We'll list it tomorrow. You have no locus.
I will complete the instruction.
You have no locus. We'll dismiss your application with cost. Mind it. You have no locus. Yes. What kind of application? He decide what will be.
From supplementary list.
Assuming that's what it was in the meeting.
Mr. Advocate General, after I assume office, I find that there was no remission sentencing committee.
Yes,
I have constituted it.
yes, Lordship has
But
constituted. Tomorrow, in
may-
fact, a remission is meeting also.
yes,
That
yes.
meeting.
So yes,
Only issue, my lord, what has happened that this policy has come into
had not been notified as yet.
31st January, we had the policy which we have circulated. There were certain issues which amicus has highlighted before the Honorable Supreme Court in its note, my lord. Only minor issues are there. Which I,
But your draft policy has not yet been finalized.
there is one policy, if your lordship will see, there are two policies. One is of 31st January, my lord.
Mr. Advocate General, you have an NHRC guideline.
Yes, my lord.
You have an NHRC guideline.
Yes, my lord.
You have an SOP of the NALSA.
Yes, my lord.
You have to follow that guideline.
Yes, my lord.
So
That is there, my lord.
much to be done.
Yes, my lord. In fact, if your lordship will see, because our policy is in line with first direction of the Honorable Supreme Court is there in the first column, my lord. Compliance with para 10 of that the answering state and is exhaustive policy.
But tell us, Mr. Advocate General,
Yes, my lord.
that when this draft policy which you have annexed in your affidavit filed before the Supreme Court,
If your lordship will kindly see my the first one, my affidavit at page 16, page 6 of my affidavit, my lord, before Supreme Court.
yes,
Annexure 1.
This is an affidavit filed on 22nd September 20.
Yes, my lord.
Correct?
20, yes, my lord. And
Now-
your lordship will kindly come to first one, a copy of the notification issued by Government of
Yes.
Meghalaya. 6. And
Paragraph 3, you have said a copy of the draft
it will
policy
come
of the
into
state.
with the publication in
is
the
annexed.
Gazette, my lord. Gazette.
Yes.
I was trying to locate the Gazette from them because it has to be. But I am
Published.
if it is approved, if it appears to me, my lord, because I took the instruction and they are acting on this 31st January. On this instruction, my lord, and your lordship will see the signature is also there at page
So
13
the
of
draft
this.
policy is pending with the state.
Yes, my lord.
You need a cabinet to approve it.
Yes, my lord. That cabinet
The
probably
cabinet meeting is this
in
month only.
19th, I am told that 19th it will be sitting, my
So-
lord. I have spoken and I tried to
So
get
can we record your submission that the draft policy will be placed before the cabinet this month,
Yes, my lord.
and it is expected that it will be
Yes, my
notified
lord.
by
Yes.
the next date of hearing.
Yes, my lord. That will be better.
This bench is constituted pursuant to Score the list.
Some supplementary list. One.
Yes. Yes, yes, yes. Yes. Yes, who's for
Am
the
I
appellant?
audible, Mulot?
Who is for the appellant? Who is for
Learned
the
friend is
appellant?
appearing for the appellant. I am for the sole respondent.
Yes.
Because in this matter, your lordship was pleased to condone the delay on the last date of hearing. Milords, I am requesting with some accommodation in this matter, Milords, if this matter could be taken up, Milords, after vacations.
Why?
The
This person is not getting the benefit. There is no
Yes, Milords.
you extend the benefit subject to the result of this appeal.
Milords,
You
in this
extend the
case,
benefit subject to the result of the appeal. Where is the AAG? Additional Advocate General?
Milords, I've been marked, Milords, this matter just recently, Milords. The matter, as I could see, Milords, from the impugned order concerns, Milords, extension of the benefit of the CAS scheme
Yes.
to the petitioner. And the petitioner, Milords, in this case is admittedly not possessing the first class marks in the master's degree, which is required by the AICTE notification. The AICTE notification, Milords, categorically provides that you need to have first class in the master's degree. In point 10 of the clarifications, Milords, that is there in the petition. And he has scored, he is trying to seek, Milords, a benefit of 5% relaxation, which is available only at the time of direct recruitment and not at the stage of promotion. So, Milords, that is the sum and substance of the matter in this case, Milords. And in order to assist your lordship better, I was seeking, Milords, if the matter could be listed immediately after the vacations, Milords. The notification, Milords, is absolutely clear. And the relaxations available as far as the direct recruitment are concerned cannot be extended by way of legitimate expectation to promotion. And there are judgments of the Supreme Court also as recent as 2019 saying that there can be a separate criteria for promotion as compared to direct recruitment.
No, he is claiming out for a AICTE pay scale, correct?
Yes, my lords.
And he has given that AICTE pay scale since 2009.
Yes, my lords.
Then?
And the
in the-
AICTE pay scale, my lords, now he wants from from lecturer to lecturer senior grade. And lecturer senior grade requires you to have first class in the master's degree. That my lords can find at page 233, point number 10.
No, but it is for the post of lecturer.
Yes, Manoj.
Now, if for the post of lecturer, initially it was by direct recruitment.
Initially, it was by way of direct recruitment.
Then there came this caption issue related to qualification.
Yes, Manoj.
So, for the post of lecturer, there has been now a relaxation in minimum qualification criteria, rules stating reservation for the respective categories. So, for the post of lecturer, he is applying for the post of lecturer, correct?
He's been working at the post of lecturer. Now
so-
the issue pertains to his pay scale for lecturer senior grade.
Yes, lecturer senior grade. So,
And page 233 is the AICT notification. At point number 10, it
no,
says
if
that
he,
you
if
need
he
to
belongs
have
to the if he belongs to the reserve category, then for the
Yes,
purpose of the appointment of the post of lecturer, there will be relaxation of qualified marks by 5%.
Yes, Manoj. That benefit has been extended to him.
Then what
That
is
benefit has been. Problem is, my lords, here the issue is concerning his revision of pay scale and his promotion to the post of lecturer senior grade. For lecturer senior
but
grade, there is a
what is the
category.
what is the qualification for the lecturer senior grade?
Because that requires first class in bachelor's or master's, and he is not qualifying that first class qualification, and that relaxation is not available at the stage of promotion. That is the issue in this matter, Manoj.
Mr. Sen,
Yes, my lord.
how it can be extended to at every stage?
Yes, my lord. I'll just. No, my lord, what happened, your lordships? Now, Polytechnic, my lord, this imparts, my lord, diploma. Now, normally, my lord, so far the state of Meghalaya is concerned, till the year 2009, my lord, they were under state pay scale. What are the qualification, other thing prescribed by the state government, not by AICT. Now, in 2009, my lord, state of Meghalaya has decided to extend the AICT pay scale, provided they fulfill the qualification to those stages. Now, AICT general qualification to be eligible for AICT pay scale plus other benefits, my lord, is first class. I am not disputing that. Is first class, your lordships. And admittedly, my lord, my mark is 55.25. But they were conscious of the fact, AICT regulation subsequently clarified, so for the reserve category of candidates, not direct recruitment, in the matter of appointment, they are eligible, my lord, entitled to the concession of 5%. Now, there is no.
That is at the entry level.
My lord,
That
it
is
did
an
not,
entry level
it did
for
not
the-
say direct recruitment. It say appointment. I'll come, my lord. Subsequently, what is appointment also, my lord, clarified by the AICT regulation. Appointment means, my lord, they have clarified and learned single judge has taken note. Appointment means direct recruitment as well as promotion. That also has been clarified by the AICT.
No, appointment and
Appointment includes, my lord, both direct recruitment as well as promotion. This promotion is also a mode of appointment. That has been clarified by Supreme Court also. I have referred to those decisions before the learned single judge. Now, my lord,
appointment would mean the initial stage.
my lord, appointment, my lord,
It is not that you are appointed to the. That is by your when the appointment normally generic meaning would be that at your initial stage you are appointed as a lecturer means you are appointed.
lordship,
Now by reason of promotion,
my,
you are now being appointed as an additional say assistant professor.
my lord,
Now this notification which is there,
lordship,
5%, it means that it is comparable to the entry level of lecturer. If the lecturer direct promotion, so when there is a direct promotion, in addition for the SC/ST reservation, they said that for the minimum qualification for that particular post,
lordship,
5% relaxation would be given. So if it is say 55% for eligible for direct recruitment, 5% would be maybe 50% for that for the purpose of if they belong to SC/ST for direct recruitment.
lordship.
But then at every stage,
No, my lord, I'll just clarify, my lord. Otherwise, you know, for time being, your lordship forgets that promotion is not a fresh appointment. My lord forgets it. These will lead to a absurdity. What my learned friend is saying, in entry level, you are entitled to 5% relaxation. But if you entered the service with 5% relaxation, then you cannot move up. You are not, that's what my learned friend is saying.
No, that's
what my learned friend is saying. You are not entitled to promotion. That means those who entered the service with, my lord, this relaxation of 5% mark, they will enter the service, my lord, as a lecturer. But when it comes,
they will be the same cadre with the lecturer.
Same cadre with the lecturer. But when the promotion, my lord, comes, question of promotion under CAS, that these promotion, my lord, basically, my lord, these are not the normal promotion
No,
like
no,
a
7 years or 10 years stagnation because of the
my lord, career progression scheme, my lord. So when the, my lord, question of promotion comes, he will not get promotion, my lord. These will lead to an absurd situation.
No, you will not get a promotion because at the entry level he was not having the that was shown as a disqualification.
That will be, my lord. I will not get promotions. If I can take, my lord, briefly, this will clarify everything, my lord, to page 131. Now, 131 is the, my lord, regulation issued by in the year 2016 by the AICT. This is with reference to both, my lord, not direct recruitment as well as CAS, Career Advancement Scheme. Now, my lord, my placement under, my lord, for selection grade lecturer, this is under Career Advancement Scheme. My lord, if comes to page 231.
You want time. You said you want time. You are not ready.
Yes, my lords. I just wanted, my lords, in order to assist your lordship better, that immediately after vacations, my lords, any day which is convenient to the opposite side, my lords.
The matter is heard in part. Let this matter be listed on 27 January 2026.
Yes.
You can file your
Obliged.
short notes of argument in the meantime.
Lordship.
Yes,
Short
we'll do
argument
that.
may be filed in the meantime.
Obliged.
Yes, we'll do that. Obliged.
Number 2.
Yes.
Uh, by the, my lords, Power Corporation.
Yes.
Well, this matter pertained to challenge to an order whereby, my lords, the petitioners had approached the writ court seeking regularization of their services in lieu of certain lands which were transferred by their clan.
Regularization.
Regularization of their services in view of certain lands which were transferred by their clan to the Power Corporation
It's
for the
not
purposes
appointment.
of setting up.
They were given appointment
Yes,
as a land loser.
they were. Yes, my lords. They were given appointment and they are now seeking before the writ court regularization of their services.
Now, what was the scheme provides for land losers?
My lords, yes, my lords, here the distinction was this was not exactly a land loser situation because we had a lease document with the clan. And secondly, the lease document or anywhere in the transaction, the negotiations for this transfer for on lease, there was never a situation for providing appointment to any members of the clan. So all of it, my lords, emanated after 7 years of the transfer. By way of an afterthought, these two petitioners approached the writ court for the purposes of, my lords, regularization of their services.
When you have taken the land,
My lords, land was taken way back in 2017. The negotiation started. I have, my lords, filed my written notes of argument. If your lordship takes up, there is an entire list of dates. The negotiation started on somewhere around 3rd of February 2015.
yes,
And my lords,
3rd
on
of February.
26th, 2015.
Yes. Yes.
Yes, Manoj. And your Lordship sees, if your Lordship has the written notes, the appellant corporation through additional chief engineer requested the Kharkhongar clan for land in order to construct a substation. And Manoj, it finalized at item number 4, which is 22nd of March 2017, bottom of that page. Appellant Corporation had approached the Kharkhongar clan requesting for land for the purpose of constructing a substation. Consequently, a patta was issued in favor of the Appellant Corporation for the land named as Mosaw, located at land Smith East, Khasi Hills, for around 45,500 square feet based on the conditions mentioned in the patta. And my lords, kindly note the conditions which are mentioned. The conditions specifically provided for payment of yearly lease amount of 500 rupees. The patta was valid only for a period of 15 years. Patta reserved the right of the clan to enter the land at any time and do necessary action in respect of the boundary of the land or any dispute that may arise in respect of the land. Appellant Corporation was required to surrender the land if it treats others ill in regard to the land. Patta on a bare reading does not reflect to be a gift and rather it appears to be in nature of a lease. Patta does not provide any record or any agreement to give jobs to any members of the clan. So, Milord, this was the sum and substance of the relationship between the Appellant Corporation and the clan, and it was in the year 2017. And this writ, my lords, was filed in 2023. At item 16, my lords.
No, but where is the official memorandum? It is 17th November 2014.
17 November
2014, which was mentioned in your OM of 30th August.
Yes, my lords. Yes, my lords.
Where is that?
I have filed, my lords, with my rejoinder. Rejoinder has been filed, my lords, subsequent to orders of this court.
Where is the rejoinder? Yes.
Well, this has been filed on 31/10/2025. Rather, it is affidavit in terms of order dated 15/10/2025, and in reply to the rejoinder affidavit filed by the.
No, but where is that document?
Yes, Manoj. In this, Manoj will find. Manoj will find it annexure number A at page 11.
I think it's page 32.
Yes, Manoj.
Running page 66.
Yes, Manoj. So this is, yes, Manoj, this is pertinently the office memorandum. 17th November. Ideally, Manoj, this office memorandum should have been placed with the writ petition, and the learned single judge did not have an opportunity of examining this office memorandum. A reading of this office memorandum, Manoj, categorically shows that this office memorandum was for the purposes of appointment in the state government. It does not really pertain to the appointment to be made in respect of an autonomous independent corporation like the Power Corporation, which is the appellant herein. And Milords may note para 7 of this office memorandum, appointment, which is at page number 38.
And anyone for the state is appearing.
Milords, I am appearing for the appellant corporation. State is not a party. in these.
Now, is there any policy of the state that land losers or something, because this memorandum to which you are making reference
Yes, ma'am.
was in modification to the memorandum of 17 November 2014.
Yes,
Now,
ma'am.
now it says that and to say that for the existing paragraph 7, so the
Yes,
existing
ma'am.
paragraph 7 was
Appointment to family, appointment
yes.
of one family member.
So you are not correct in saying so, because already when this was constituted in paragraph in 2014,
Yes, ma'am.
this has taken care of family member of land owner donating land. So this was
Well,
modified. So direct recruitment, they will take into consideration they also come within the categories of the claimants whose appointment are to be made by the district level, that district council. So in case
yes,
where
ma'am.
owners have donated free of cost to the government, the land proposed to be donated should be legally handed over. The commission also will identify the post. Yes, identify the post in consultation with the district head to which the land is being donated. Appointment under this provision will be outside the purview of the district selection committee. So this will be done by the deputy commissioner.
Yes, Milos, there are two submissions.
These categories have been taken out from that particular memorandum. It will
Yes,
be the
Milos.
district will identify in constitution district head. Now,
Milos, a reading of this memorandum also shows that it applies to the state government. Milos, I do not have the wherewithal to identify posts in concerned districts and so on and so forth, Milos, because this memorandum never applied to me. This memorandum never applied. It is because the petitioner wants to seek regularization. They are trying to take benefit of this memorandum and the modification and the new avatar of this memorandum, which is annexed with the writ petition. But this memorandum precisely is for the state government. State government is a mammoth organization. It can identify posts by way of deputy commissioner, and it can provide jobs if the land is given for governmental purpose. But I am a corporation running, providing distribution services of electricity. So this memorandum,
who is 100% shareholder of your company?
well, it's a government undertaking. I'm not denying that. I'm not denying that.
It says the donated land free of cost for government purpose. It is not a government purpose.
It's not a government purpose. It is not free of cost because I have paid Milots 1 lakh rupees, and by virtue of
it is not for. It is a public purpose.
It is a public purpose, and monies have been paid as demanded. I have put that additional document on you.
And this 15 years, please. So if you calculate when the land was taken,
Milos 2017.
So it is going to expire in 2032.
Yes, Milos. It is going to expire. It's a lease. No, it's not a complete gift under Section 113 of the Transfer of Property Act.
But what you have done on the land?
Because the substation has been created for the benefit of the community. Substation for electricity distribution has been created.
So question of surrender doesn't arise as such. Because
as such,
ultimately the government becomes owner of the property.
It's not really, the clan has the land and it wants a substation to be developed so that members of the community can be benefited with electricity. Now there are petitioners who want to take benefit of that transfer, saying that my clan transferred it because my clan wanted to give jobs to me.
But if it's done to the clan only. If the clan has given this,
Yes, ma'am.
then individual, and moreover it's a lease, 12 years lease. How can you claim a...
Well, quickly respond, my lord. There are two aspects, my lord. The fact that my clan, in a sense, my family has given the land still brings me within the ambit of the scheme, of this state government scheme. Now, my friend appearing for the Electricity Corporation is trying to distance himself from the scheme by saying that he is not a government, etc. But
No, you go by the agreement.
Yes.
There's an agreement, and 500 rupees he has to pay.
No.
That is the agreement.
My lord, that was subsequently waived. That was the initial the initial understanding was that they will pay us rent of 500 rupees per year, plus in Meghalaya there is a system of a token sum being paid for issuance of the patta. So if it is an outright sale, my lord, or an outright transfer of something like a lease, then there are two components of payment involved. One is for the transfer itself. Either you pay annual rent or you pay a sale consideration. Second component is a token amount for the patta. In this case, initially, the understanding between us was that they will pay both the components, 500 rupees per year for the land as lease fees, as lease amount, and 1 lakh for the issuance of the patta. Subsequently, they themselves made a request, pointed out to us that if you take 500 from us, then the gratis nature, it is no longer donated land. It is leased land. So they asked for a waiver of the 500. We agreed to the waiver. So they have not. There is no question of payment of any lease amount. Remains the 1 lakh rupees. 1 lakh rupees they have paid to us for issuance of the patta. Their own documents, which is on record, themselves acknowledge that this 1 lakh is being paid for issuance of patta in respect of the donated land. So my friend's attempt to project that there is sale consideration involved does not hold good, because their own documents show that they have acknowledged that it is donated land for which they have paid a token amount for the issuance.
Normally, donation doesn't require any money. Donation, if you donate something, so donation does not mean in reciprocation of this, any money is paid. That is a gift. It's a gift.
It's a gift.
So basically, it's not a gift. Whether the donation word is used or not, it is for a consideration. The word donation in legal parlance would mean that you gift it. There cannot be a gift with a consideration. Yes, other love and affection is other consideration.
True, my lord.
Or for purpose. So there is a consideration of 1 lakh you have received.
My lord.
As a consideration.
My lord, I bow down to what my lord has stated. But the context in which the word donation has been used in this transaction, my lord, is very clear. The understanding between the parties is that we are giving you the land for free. But as is the practice, as is the tradition, as it has always been, you pay us a token amount for the issuance of the patta. If it was a private person, an ordinary person, token amount is sometimes as low as 1 rupee. Just a token symbolic.
And then there was no condition that in lieu of this they will give you employment. There is no condition as it is in the agreement.
No, in the patta, my lord, patta is a land document.
In the agreement that you have with him,
yes, my lord,
there is no condition that this land is in lieu of that will give you a job.
No, my lord.
There is no policy as such which says that you'll be entitled to a job.
My lord, in the agreement itself, I cannot run away from it. There was no such condition present, my lord. But what is important, my lord, is that subsequent to the issuance of the patta, when we donated the land in 2017, we went to them and said that because of the scheme, we are entitled to employment. They kept us waiting for 3 years. In 2020, my lord, we have received employment. What we have received, my lord, is contractual employment. 1 month before we were employed, 20 other similarly situated persons whose families had donated land as far back as 2005, 15 years back, they received permanent, regular employment, my lord. So what my friend has missed out in his submissions is that in the writ court, before the learned single judge, our primary case was a Article 14 issue. We were seeking parity with similarly situated persons who have received employment.
Suppose they were given employment, dehodes a provision.
My lord,
there is no question of any negative equality.
My lord,
there is no question of any negative equality under the law, constitution.
My lord,
if one has got a order contrary to a scheme that does not give you a cause of action?
No, it doesn't. It doesn't. I'm very thankful that Lordship has brought up this point, because negative equality, for negative equality to come to their assistance, they have to stand up and say that the appointment we extended for the 20 other persons was a wrong appointment. It was a violation of the schemes. But what has happened?
Now, what is their stand on these 20 persons?
I'm just coming to that. My Lord, our learned single judge, in my case, passed his judgment. Lordship's brother judge, Justice Dinglo, passed another judgment in a matter involving the same corporation. If I can.
He never gives understand. I don't know.
The primary issue was a slightly different issue. It was for equal pay for equal work. But the question of these 20 persons who were appointed had come up as an incidental issue. Para 27 of this judgment may kindly be looked at. This pertains to that 20 persons who were appointed. If I can read, my Lord. As to the contention of the petitioner union as regard the alleged discrimination as far as regularization is concerned, particularly the process for regularization of 20 employees, the explanation offered by the respondent MECL that the said 20 employees were regularized on the basis of an agreement made between MECL and the landowners, etc., for appointment of the preferred candidates, the same cannot be faulted, since the policy decision of the government in this regard would cover such a decision. The said policy is found in the office memorandum number so-and-so, dated 30th August 2017, annexure so-and-so, where the following is noted. The OM is extracted. This is the very same OM that is the focus of our case, my Lord. So,
no, what his lordship has said is paragraph 21. Read it.
21.
For the aforesaid position in the foregoing paragraph, we have no hesitation in holding that all the temporary employees concerned in the present bunch of cases would be entitled to draw wages at the minimum of the pay scale. Excellent regular. So if you this at the highest, what you can claim is that if you are discharging the similar function, then you will be paid the same basic minimum wage as the regular employees are paying. That is the ratio of the judgment.
My Lord, the ratio.
I'm not wrong.
My Lord, the ratio. I admit, my Lord, the issue here, the primary issue was equal pay for equal work. But
see, for equal pay for equal work, there are various criteria to be fulfilled.
My Lord, I'm not on that. I'm not seeking equal pay for equal work, my Lord. What I'm seeking is parity with those 20 persons similarly situated who received regular employment, whereas I received contractual employment, my Lord.
No, but are they similarly placed?
They are absolutely similarly placed.
Are they similarly placed?
Their own documents.
Not at all, my lords. Not at all. My lords, I filed an additional affidavit pursuant to a leave granted by this honorable court under Order 41, Rule 27. My lords, that 20 persons were given appointment for land because there was a specific promise made to them in acquisition of that land in 2013. And that document I have placed at page 17 of my additional affidavit. So that case is, yes, my lords.
Page 17 of the
additional affidavit dated 8th of July 2025.
Eighth of
July, 8/7/2025.
Page 27, it ends in 22.
17, 17, 17.
17, yes.
It starts, my lords, and page 19 is relevant. So, my lords, this 17, your lordship has noted that this is dated 24th November 2005, when, my lords, the corporation was in its previous avatar of a state electricity board, and thereafter, my lords, corporatization happened in 2010, and page 19 is the specific undertaking. The project proponent, paragraph 3 of page 19. Project proponent clarified that in all the projects executed by MSEB, such as Umyam, Umtru, and Diksha, preference for employment has been given to the local youths for the respective. However, in this case, so and so. Just a second. Yes, Manoj, the second paragraph. Shri Bhaskar Dindo was also of the opinion that due consideration be given to youths for the area of employment in the proposed project. So we made an undertaking, Manoj, during the acquisition of that project, and therefore employment was given. In this case, that is not the situation. And in the
Is it the same kind of project?
no, my lords, there is no. It's not the same kind of project, because if your lordship sees at page 17, where it is starting, it is the new Untru Hydel Power Project proposed to be set up. It's a huge hydro electricity project which was being set up, my lords, and it was required that the land be acquired for that purpose. Otherwise, the electricity generation and distribution across the state would have been affected. Here, it is a substation for a locality which is being talked about, my lords. And in this situation, I have placed, my lords, the file notings, which goes into the reasoning behind employment of these petitioners. This is a mass recruitment for increasing efficiency. I have placed, Milos, in my the latest affidavit of reply, that the file notings indicate that they have been employed for increasing the efficiency, and number of people have been employed. So their appointment, temporary appointment, had nothing to do with the so-called transfer or giving of land on lease by their client.
Now you see that this substation which you have constructed is for public
Yes,
purpose. It's for public purpose.
Yes, Lord.
Electricity, it is, if it is a rural electrification, there is a scheme. So it's a duty of the government to ensure that every part of the state, even the remotest area, receive electric connection. You require the land.
Yes,
Either
yes,
the government acquire the land for you, or you purchase the land. Now you
yes,
have
Lord.
entered a agreement with them against a patta of 1 lakh. There was a
Yes.
lease agreement executed, which is for a period of, say, 12 years
15 years, Lord.
or 15 years. Now, what would happen after 15 years? The substation cannot be abandoned. It is for all practical purposes. A substation would
Yes,
remain. There is no question of, because you have been given right to construct a substation. So the
yes,
question of even dismantling the substation doesn't arise.
yes, Lord. There will be, Manoj, further negotiation for extension of lease.
You make the state of Meghalaya party and serve a notice upon the Government Advocate General. Take down. During the hearing of the appeal, we are of the view. thought you would be that this is a understanding. Yes.
If it pleases your Lordship Miller, this matter may be taken up after the vacations, Miller.
After the vacation, very well.
After the
On the prayer of the learned senior counsel for the appellant, the Patterson's adjunctive
of the witness, number 1.
What does this matter?
May it please your lordships. Lordships, I'm craving leave of this honourable court to withdraw ourselves as counsel in this matter, lordship.
Withdraw yourself as counsel. Why?
Lordship, it had come to our notice. It had come to our notice, lordship, that senior counsel conducting us in this matter, lordship, he had appeared for the private respondents in an earlier occasion, lordship.
Take note.